as Tammy just said, I'm a labor and employment lawyer. I represent only management. I've been doing this all my career. And what we're going to talk about today is sort of, I think, one of the more difficult topics in labor and employment law. And it's because we're required as human resource professionals to think like doctors, and we're not doctors. And so everything that these laws sort of prescribe require us to think outside the box. And recently, you know, these laws have been passed a long time ago. We're going to talk about them, but they've been amended, and they've added different protections, and there's things that you may want to go back and update your policy manuals on. There's things that you may want to think about when you're dealing with military reservists and so forth. And as we go through this, I'd like it to be interactive. And this is kind of a big rectangle, and so it might be difficult to be interactive. My eyesight isn't that good, so stand up or shout or something if you have a question or a comment. And I'm going to give you my email address. As attendees, everyone is entitled to email whatever questions you have. And if I know the answer, I will respond. And if I don't, I'll just act like I never got it, and that'll be that. I'm joking. My email is rlarkin, L-A-R-K-I-N, the @ symbol, the letters A-N-B, like Allen Norton Blue, law.com, rlarkin@anblaw.com. The overview of what we're going to talk about today is the recent amendments to these employment laws. The Americans with Disabilities Act, Family Medical Leave Act. There's some military leaves and some veteran recruitment issues that have come into play in FMLA. The Fair Labor Standards Act. USERRA has been amended, the Uniform Services and Employment Reemployment Act. And then we're going to talk about at the end where the rubber meets the road, how all of these things kind of come together. And I've had people say, well, it's like the Bermuda Triangle. It's this. Well, it is sometimes, but we're going to talk about different scenarios. If anybody wants a copy of this, just, again, send me an email and I'll be happy to shoot you a copy of it. I don't know if you have it in your materials or not. I doubt it. But that's sort of what we're going to discuss today. Now, the basics. Americans with Disabilities Act. We'll start there. Basics of the ADAAA was passed in 1990. There's been no real amendments to the law since it was passed. It's 2012, so that's 22 years that law has been in effect. This should come as no surprise to the human resource professionals in this room. Now, when it was passed, though, Congress believed that there were 43 million people who were needing or deserving of an accommodation in order to be able to work. And so they drafted this law with the idea that it would be very broad in its application. And so that was the original intent of the Americans with Disabilities Act. And what the Act does is it protects individuals with disabilities and encourages reasonable accommodations so that individuals can remain employed. And so over the years, though, courts have interpreted this law and interpreted it and have broken it down into its components. And one of its components is the term disability. Disability is a term of art. If you ask the citizen on the street what is a disability, he or she probably has a pretty good idea. But what he or she thinks is not what the law is. The law is, it's a physical or mental impairment that substantially limits one or more major life activities. Well, what does all that mean? Well, each of those terms are terms of art. The term impairment, the term substantially limits, and the term major life activity have all been litigated over the last 22 years. Now, you can also be disabled for in a couple of other ways. And we probably won't spend a whole lot of time about this, but you could have a record of an impairment which can qualify as a disability. For example, perhaps you have an employee who was diagnosed with some type of illness 10 years ago or 20 years ago, and they have this record, and because there's this medical record out there, you treat them as disabled. That can work, even though they may or may not be disabled. Another type of disability is regarding somebody who may not even be disabled. For example, there was a famous case where a school teacher had what was rumored to have had hepatitis. And she didn't, but they believe she did, and they regarded her as that. And so this disability idea under the law is a lot broader than just simply having a disability. You can have a record of having one, or you may not even have one, but your employer thinks you do, and that may be enough as well. So it's very broad. Now, reasonable accommodations, we've all heard that term, and we'll talk a little bit about that today, because the way the law has been changed, that to me is the most significant area where we are going to have to change our approach, if we haven't already. Now, a reasonable accommodation means just that. It means that whatever the accommodation is, it has to be reasonable. It just doesn't have to be what the employee wants. I had a case, this is 10 years ago, 15 years ago, one of the first cases that I got. And it had to do with a helicopter pilot who flew helicopters to offshore oil rigs. And she was exiting a Montgomery Ward department store. Remember those? And the door blew back into her when she was coming out and hit her shoulder and dislocated it. And it was pretty significant trauma, and she had to have a series of surgeries, and it limited her ability to raise her arm above her head. And so she wanted to come back and fly helicopters, naturally. So we say, okay, can you fly the helicopter? Well, almost. I just can't reach these toggles up here. But if you put another pilot in the helicopter with me, I'm good. He or she can reach those toggles, and I'll just steer. Now, does that sound reasonable? We said that's not reasonable, because I want all my pilots to be able to fly independent of one another. So we're not going to do that. She sued us, and we won, because it wasn't a reasonable accommodation. It was the accommodation she wanted. So just because an employee wants a particular thing doesn't mean they get a particular thing. Another example, I had a case where an employee had a car accident several years in the past, and had some of her vertebrae and her neck fused together. And she was a computer programmer and would sit at the state workstation and program computers all day long. And she would complain that I need an ergonomically correct workstation. This is not ergonomically correct. So what do? We bring down an ergonomist from New York City. And he comes in, and after a battery of tests, determines that her workstation is ergonomically correct. It's perfect. You're sitting right, your feet are on the floor, your back straight, all this stuff. No, it's not, she says, because I want a recessed monitor so I don't have to hold my head back to see the computer screen, because I wear bifocal glasses. We say, well, why don't you just take the bifocal glasses off, right? Well, if I do that, then I can't see everything that I want to see, because I get some pictures of my grandkids, and then there's the clock, so I got to know when I got to go, and I just don't like it. I want to be able to wear my bifocals and see the computer screen. So we haggle and we haggle and we haggle, and wind up not buying her this recessed workstation. It's like $600. I mean, at the end of the day, we could have just given her the $600 workstation and been done with it, but we didn't. Because what were we afraid of? Like everybody else, well, now everybody's going to want this same workstation. We're not buying it, right? So we don't get it for her. Lo and behold, she sits there and complains and complains and complains, and all of a sudden, her fusion fails in her neck, and she has to have significant surgeries, significant pain, is now completely, totally disabled and seeking Social Security disability benefits. And what does she say? She says, Larkin, you didn't get me that workstation. I'm suing you for disability discrimination. We're bumming, because I mean, for $600 we could have really saved this issue. Well, what happens? We win. We win summary judgment. Why? Because she doesn't get the workstation she wants. She gets the reasonable accommodation, she gets the accommodation that's reasonable, and our offer to buy her single focal glasses, 2 pairs, so that one could be for the computer and one could be for looking at the grandkids, she refused. And the judge ruled that she refused a reasonable accommodation, and therefore she was not qualified with a disability under the ADA. So just because someone wants a particular accommodation, I've had people come in and say, I want this whole building painted because the paint is causing me allergies. Well, it's going to get expensive. So when you evaluate these accommodations, you have to evaluate them for reasonableness. Now, I'm not saying to not buy the $600 workstation, because in retrospect, we should have probably bought the $600 workstation. But the reality is, what someone wants and what is reasonable are often 2 different things. Now, what happens? In 2008, this law is amended for the very first time. And it's oddly enough, the Americans with Disabilities Act Amendments Act. They got real, they actually just called it the ADAAA now. And so what this does, though, is it expands the definition of disability significantly. Today, the ADA is a much more broad law than it ever was. Today it is. The EEOC, now why this is sort of relevant today is because last year, see what happens is when laws are passed, everyone goes, oh great, a law's passed. And now we have this law. What does it mean? No one knows. No one's applied it yet. So what happens is Congress then gives it to somebody like the EEOC or the Department of Labor or some entity, some federal agency, and says, look, draft some regulations and figure out how this is going to work. Well, the EEOC did, and they did last year. So now we actually have regulations on how this law is supposed to work, and they came out June 24th of 2011, so less than a year ago. Now that we have these regulations, and by the way, just because the EEOC or the Department of Labor or any federal agency promulgates regulations, that's not law. That's just an idea of what the agency thinks the law should be. But it's not law until court decides it. So just because these things are out there doesn't necessarily mean that they're set in stone. So they're going to be subject to quite a bit of challenges over the next upcoming years. But these regulations, as you'll see, make it significantly easier for employees to qualify with disabilities. The ADAAA regulations still require that there be an individualized analysis, okay? So what I mean by that is whenever you're determining whether somebody is disabled, you have to determine based on their individual issues. Just because somebody has an impairment doesn't mean that you will react to it the same way I will react to it. I may be better able to perform my job because I've just somehow learned how to handle it better. I can withstand a higher threshold of pain, whatever the case may be. So that individualized analysis is still there. But what it does, though, what the law does now, is it creates a presumption. And the presumption is you are disabled unless the employer proves you're not. And that is significant because it is a lot harder to prove. It's a lot harder to disprove something sometimes than it is to prove it. The employee walks in and says, I have a disability. And what are we left to do? No, you don't. You can do that. You're kidding, you're joking. That's not legitimate. Whatever the case may be. That's a hard thing to do. So what you're going to find out is that more and more impairments are now disabilities, and our defense of you're not disabled, this isn't a substantial impairment, is no longer applicable because you're presumed now to have it. And a presumption is a very difficult thing to overcome in a court. It's a very difficult thing because when when you are in a court of law and the judge is presuming something, you have to have concrete evidence that shows that it's not. And judges anymore, they don't want to get involved in the doctor aspect of the ADA. They'd rather just determine that something's a disability and move on and get to the real meat of the issue is, after you learn they were disabled, what did you do? What did you do? But that's how the ADAAA has changed the ADA. It also lowers the bar on what is a substantial limitation. Now, it used to be that you would have to have a substantial limitation to what is called a major life activity. And major life activities are things like walking, seeing, working, caring for oneself, those types of things. And you had to be substantially limited in that area. So what you were seeing a lot of times was, let's say, for example, somebody had carpal tunnels. And they would say, I have a disability, I have carpal tunnel. And I am substantially limited in the major life activity of working. I can't make these widgets because my hands hurt or my wrists hurt. And the way that the law would apply it would be, if you claimed that you were substantially limited in a major life activity of working, you had to be limited in what was called a broad class of jobs. And so the courts would get into the situation of trying to determine whether making widgets was a broad class of jobs. Things like secretarial work, clerical work, that's a broad class of jobs. Law enforcement may be a broad class of jobs. And so we were getting into, you had to be substantially limited in a big area of jobs in order to be protected. Now all of that has been lowered. You do not have to be substantially limited in a broad class of jobs. So if the average person can do whatever it is, and you can't, you are disabled under the ADAAA. No longer do we look at a broad class of jobs or major life activities and compare and contrast whether you can do this or not. We look at you as compared to the average person who's not disabled and say, are you substantially limited? And if you are, in any way, you're disabled. So as you can start to see, that this is becoming, we're going to have many, many, many more types of claims of disability. And employees who are claiming this are going to be able to hurdle the first aspect of this, which is disability definition. Any questions? Now, another issue that the ADAAA has changed are what are called mitigating measures. All right? For example, I know you think I'm wearing these to look cool, but I'm not. These are prescription, and I need them to see. There was a case, pilot case, went all the way to the Supreme Court. Pilot said, or Continental Airlines said, you have to be able to fly an airplane with 20/20 vision uncorrected. Uncorrected, you got to have 20/20 vision. They say, well, I don't have 20/20 vision, but when I put these glasses on, I have 20/20 vision. Can I still fly? They said, no, you're disqualified. They say you're discriminating against me because of my disability. The airline says, no, we're not, because when you put your glasses on, you're not substantially limited in a major life activity. You can see. You can work in a broad class of jobs. You just can't do this one job, flying airlines. And the court bought it. And the court said, okay, makes sense. If you can use a corrective measure to make yourself correct, for example, high blood pressure medicine, cholesterol medicine, diabetes medication, corrective lenses, then you're not disabled. That is what the law used to be. The ADAAA has changed that now with everything except for sunglasses, corrective lenses. Corrective measures now are out the window. When the ADAAA was passed, Congress specifically said, we want these 3 cases overruled. They wrote that in the law. They cited to the cases. I've never seen such a thing. But they are like, these 3 cases that the courts have decided, we don't like those cases. We are changing the law, and we specifically are changing those 3 cases. So now, if you're a truck driver who has high blood pressure and UPS tells you you can't drive, and if you take your medication, you don't have high blood pressure, so you weren't disabled in the old days, you are today. You are today, even if whatever the corrective measure is, corrects you. Substantial change under the ADAAA. Now, it used to be that the ADA required permanent impairments. Things that were wrong had to be permanently wrong. Permanently wrong. For example, is pregnancy a disability? No. Why? It only lasts 9 months, right? Men wrote this law, I'm telling you. Because it's temporary, it's not a disability. It has to be permanent. Things like broken bones, well, they heal. They're not permanent. Now, you can have complications. You can have complications during pregnancy, and those complications may become disabilities. You can have complication with the broken limb, and that can become a disability. But the general rule is if it was temporary in nature, not disabled. Now, temporary disabilities, you're disabled, at least for that temporary period of time. So now we're having to accommodate perhaps temporary issues. Joe breaks his leg. Joe needs an accommodation. Joe gets an accommodation while he has a broken leg. In the past, broken leg, Joe, it's going to heal. You're going to be good to go in 6 weeks. No accommodation. Sorry. Today, accommodation. Temporary disability. All right, so that's the Americans with Disabilities Act, Amendments Act to the ADA. Those are the big picture points. Lowers the substantially limitation. It creates a broader net for disabilities. It allows temporary disabilities. It overrules mitigating measures. So what is the long and short of all of this? Everything is a disability today. That's what I'm telling you. If you start getting into this is not a disability, you're probably going to lose that. And that's not where you want to stop your analysis. That is not where you want to stop your analysis. What you want to stop your analysis is with the interactive process. Okay? All of you, if you leave out of here with one thing, leave out of here with this. The interactive process in the Americans with Disabilities Act type of cases is where you win and lose. It's the difference between good and bad, good and evil. It's how a jury looks at you. It's how a judge looks at you. And what do I mean by that? Well, what I mean by that is when somebody says, I have a disability, rather than going, no, you don't. This is temporary. You'll be fine, 6 weeks. I don't think that's rising to the level of a class of jobs. I think what you should be doing is saying, okay, you got a disability. How can we help? What can we do to help you? You have to start the interactive process. And it has to be in good faith. And what do I mean by that? When I say good faith is fancy words for lawyers to write it down. Write it down. Yes, ma'am. Absolutely. The question is, if somebody comes in and says, I have a disability, can you require them to bring documentation and to substantiate that? Of course. Of course, because then you would just be taking things at people's, representation, and that may or may not be true. But how you ask for that, what you accept, you got to have, give them a reasonable amount of time, allow them to bring something in. I wouldn't be looking at, oh, this doesn't look right. This isn't real. Is this fake? But yes, you can do that. Yes, ma'am. If the employee has not alerted you to their impairment, so you don't know about it, and so they get a bad evaluation, and then they go, it's because of my impairment. Right. Well, they cannot. No. There's a famous case, a Supreme Court case, that has these words. The ADA does not require clairvoyance. And what that means is that if you don't know, you don't know.
But it is the employee's responsibility.
Absolutely. Always. It's the employee's responsibility to, now unless what? Unless it's open and obvious. If somebody presents and they are obviously impaired, well, then we know.
You can't say I never noticed your wheelchair.
Right. Cannot say that. You too may then be impaired. But you're right though. If you don't know, then you can't discriminate because you don't know. So if the employee never discloses, and sometimes they don't. Sometimes he or she doesn't want this known. I don't want you to know of my condition. Fair enough. But then it's very difficult then for me to discriminate against you if I don't know that you have some condition. And they certainly can't come in and say, I'm getting a poor evaluation and it's all because of X impairment. So change this. Can't do that either. Because you evaluated them without knowledge of their impairment. So it can't be because of their impairment. Now, if they come forward after they get the eval and then they say, well, I'm having trouble concentrating, I'm having trouble doing this or that, and it's because of the medication, because of this, then you could say, okay, all right, going forward, we'll take that into consideration. But this stands. I mean, this is a record of how you were performing when we did not know. But going back to the interactive process and those words, good faith, what do I mean by that? And I said, that's a fancy word for write it down. And I'm joking somewhat, but I'm not. If somebody ever comes in and says, I need an accommodation, you should start putting pen to paper. Because the only evidence that you'll have are the documents between you and the individual where you tried to help get that accommodation. If you're doing all this orally, what does that mean? That means the employee one day says, I don't remember you saying that. That never happened. You never told me that. And you're left to explain. And there's an adage in employment law. If you're explaining, you're losing. It's 2012. Write things down. And the interactive process is one of your primary defenses, so you need to write things down. Create a document file of how you're trying to help the individual. And it doesn't have to be what they want. It just has to be reasonable and effective. Bifocal glasses versus another pilot. Okay? Yes, ma'am. The question is can I touch a little bit on mental issues and how do you accommodate somebody who cannot mentally function, right? Well, mental issues, you're right, are dominating. It used to be in the old days, 10 years ago, 15 years ago, it would be my back hurts. Everybody's back hurts, right? Now it's somebody has some type of mental impairment and they're taking some type of medication. And that impairment today is going to be a disability. Now, we're going to get into the accommodation issues when we start getting into this, the interplay of these three laws. But generally speaking, anything and everything can be an accommodation today. It used to be, prior to the ADAAA, that you had to perform the essential functions of your job, with or without an accommodation. And if you could not, then sorry, we're going to let you go. Today, that has changed. Now, if you can't perform the functions of this job, you got two options, employer, but you better exercise both of them. The first one is restructure the job. Restructure the job. Now, nobody likes that. Why? Because if you start taking duties out of that job, you got to give them to somebody else. And that makes everybody upset. Why am I doing Joe's work? Joe should be doing these three things, and I'm doing them now. But that's an option, and that's something you should consider. The next issue is transfer to another position. Do you have any other positions in your office that this person can do? Because, well, and so if it's a mental issue, if it's an issue where somebody's having trouble focusing, I actually got a call the other day from a bank, and they had a branch manager who was having mental issues, and he would not come to work. He would wake up one morning, he would be fine, show up at 6 a.m. Bank's not even open. He's working away. Next day, he doesn't show up until noon. Well, what's going on? I didn't feel well this morning. Next day, doesn't show up at all. Then he wants leave for 2 weeks because he's got to get his medication correct, and then he's got to go he's got to go to counseling and therapy and these types of things. And how do we accommodate that? What do? Do we say you're not disabled? Give us some. Well, we asked for the records to indicate that he was, and certainly he's suffering from a mental impairment, and he is taking medication. And so what now? We have to engage in the interactive process. Is there a way we can help this guy? Now, one thing that always exists, though, as an essential function of every job, and it should in every job that you have, is attendance. If you don't come to work, you can't perform the job. So all of you, if you do anything, you should look at your position descriptions and make sure that an essential function of all your positions is that you attend work.
If you restructure the job to accommodate, you have to restructure the pay.
You can. You can. That's a great question. If I restructure the job to accommodate you, can I restructure your pay? Yes. Yes. If I take all of your duties away and give them to someone else such that you are now no longer office assistant 3, you're more like office assistant, then you don't get 3 pay, you get 1 pay. Yes, sir. You know, that is the dilemma, and that's a great question. The question is we got somebody who has an impairment, presents with a disability. We want to transfer that person, but we got nowhere to put them. What do? Well, you either leave them in the position that they're in, and they don't perform how you need that position performed, and you evaluate them and you terminate them because they're not performing up to your standard, or you just terminate them because you got nowhere else to put them. And we made that decision the other day at another client school board who had a assistant bus driver who wanted an accommodation. The assistant bus driver is incontinent, and because of that, was unable to care for himself on the bus, and the students were complaining. And he wants a accommodation of a nurse to ride in the bus with him. And the school district says, Larkin, do we gotta get a nurse to ride on the school bus with this individual? And the answer is no, that's not a reasonable accommodation. We can't stop on the side of the road and have this go down with all the students in the bus. And so we don't give him that accommodation, but he can't do the job. It's not sanitary. So we look all school district wide for accommodation. Where can we put this guy where he can do work that's sedentary, that's open, that the position is open, that we can put him in? And there wasn't one, and so we let him go. And he's hired a lawyer and wrote us a nasty letter and probably going to sue us. But there are some times in what we do that we just can't get around these types of things. But as long as you engage in that process and you look and you take every action that you can, you should be okay defending it. Yes, ma'am.
And just want to be what you did to look and serve.
You got it. You got to document. We turned every rock over in that school district looking for a position for this guy because we know he's going to take an action against us. This is the only job he has. He will earn no money after this. So when you're left in that situation, you know that when people are desperate, they're going to resort to what they can. And he's going to bring a claim against us. And so that's what we did, and we documented it. I feel pretty good about what we did. I'm hopeful that the people that were looking for this position were competent. You know, if they're out there searching for an alternative position for this guy, that they were actually doing it legitimately. I'm hopeful that that's the case. But let me also say that one of the aspects of these laws too, whenever you get involved with the ADA or the Family Medical Leave Act or the Pregnancy Discrimination Act or workers' compensation, what do all of those things have in common? They all deal with a very bad fact pattern, a very sympathetic fact pattern, a very vulnerable fact pattern. People are injured. People are suffering from disabilities, cancer, mental impairments. People are pregnant and they're very vulnerable. And so when you take action against anybody in this situation, you have a fact pattern of sympathy that you have to overcome. Because those members of the jury are going to look at that person who's going to present very pitiful. They're going to be disabled, or there's going to be something that has happened. Their loved one has since passed away. Something has happened that's been traumatic. And the jury's going to look at you immediately and go, what did you do? And you have to be able to say, I did everything I could. I did every single thing I could. Look, here's the documentation to back it up. I did it all. There's just nothing I can do. And at some point, there is nothing that can be done. It's the way it is. But that's what you have to be prepared for now with the ADAAA. Yes, ma'am. Can be. Depends on how it manifests itself. I'm stressed right now, right? But I'm, I think I'm all right. But maybe later this afternoon I'm not so all right. And so if I take medication for it and it manifests itself in a particular way, then it can be. But the normal stress that we all sort of feel, probably not. It's going to have to be something that, generally speaking, is diagnosed.
Or less stressful.
Find me one too. No, but that's not going to fly. If they have, let's say, they have a mental impairment, like they have been diagnosed as bipolar or something, and stress is contributing to that condition, then that might be. He could, but see, now you're passing us all up. You're so. The question is the guy at the bank, why couldn't he do intermittent leave under Family Medical Leave Act? Number one, the FMLA didn't apply to the bank because they didn't have 75 employees. They were little. But that's a great question, which brings us to the Family Medical Leave Act. Okay? This is the next area where we're seeing changes. Now go figure. Think about this. Now both of these laws were passed when? In the early 90s, right? Who was president? Clinton. Both of these laws have been amended when? Recently. Who's president? Obama. So the Democrats, I think, want to expand the coverage. Bush wanted to eliminate the ADA and FMLA. I'm just kidding, he didn't want to, but you can see that there's a broadening of the protections under particular ideologies. Sort of the way the court is. When the court is liberal, you see more liberal decisions, and when the court's conservative, you see that. Well, you see that in the same way in the passage of laws. Now, the Family Medical Leave Act. There are two primary. You think about FMLA. FMLA applies to employers with 75 or more employees, or 50 or more employees within 75 miles, and public entities. And but narrow all this down, and FMLA does basically two things. It protects people from their own serious health conditions, and it allows people to care for others. It's at the crux of the law. That's what it's about. So you have a self-care aspect of it, and you have a care for another sort of aspect of it. And that's when you kind of got to, whenever you get your FMLA issue, that's what you got to boil it down to. What am I looking at here? Self-care, care for another, because it may depend on how you evaluate things. Serious health condition, what's that? Thankfully, that's still intact. Serious health condition is not a disability. It's something less. And this is what I always think of a serious health condition as. It's one of two things. Okay? One of two things. It's you're out of work 3 days with a trip to the doctor, or it's an overnight stay in the hospital. One or the other. And if it's close, I give it to you, it's FMLA. I count it as FMLA. If you're the employer and somebody says, I don't want FMLA, don't you give me FMLA. I want that FMLA in my back pocket. Do you have the ability to say, oh no, you're getting FMLA? Yeah, absolutely. That's right. That's right, team. They don't call the shots. You do. If you believe the leave qualifies for FMLA, it's FMLA. Because why? Because an employee would almost never ask for FMLA if they didn't have to, because they would want to keep that 12 weeks in the back pocket and do what's called stack. People want to take their paid leave and then come back and then say, well, now I need FMLA leave. And so they stack their FMLA on top of their paid, right? So if you have knowledge, if you learn that somebody is out and it may qualify as a serious health condition, they're out 3 days with a trip to the doctor, or it's an overnight stay in the hospital. You count it as FMLA, and you send them a letter that says, I'm counting that leave as FMLA. Now, what is 3 days with a trip to the doctor? It's every single child's sickness. What do I mean by that? I have 2 daughters. They're older now, but when they were around 3 or 4 or 5, they had ear aches, infections all the time. And what did that mean? That meant 3 days they were out of school. We had to go to the doctor, get the amoxicillin or whatever it was, and give the Gatorade, and laying on the couch watching cartoons. And that's 3 days with a trip to the doctor. That's a serious health condition. That's FMLA. And I wasn't really appreciating all of that until I started doing this. And I was like, you know, they could be charging me FMLA every single time I'm doing this. But my firm doesn't have FMLA because we don't have 50 or more employees. But that's FMLA qualifying. And so it's your job, though, employers, to know where your employees are at. It's your job to know. And so what I mean by that is if somebody misses 3 days of work, your sick leave policy should mirror your FMLA policy, right? If they miss 3 days, what do? You want to call in sick for 3 days? What do you need? You need a doctor's note, right? Right on, right on. Because then you would know whether that leave is FMLA or not, right? So you can tag it as FMLA and dovetail it together. So you may want to make sure that your FMLA policies mirror your sick leave policies in that regard. It allows you to take up to 12 weeks of unpaid leave. A lot of employees still think it's paid, but it's not. It's unpaid leave. When you return from FMLA leave, what do you get? You get the same or equivalent position. You may or may not be entitled to the exact same position, okay? But it has to be same pay, same benefits, same promotional opportunities, same requirements in terms of its prestige in the company. You can't take somebody and put them over here and now they have less promotional opportunities, or they work in a department that's not regarded as highly prestigious as another. At least that's what they'll say. So it's equivalent. And last but not least, you got to maintain their insurance benefits. Now, in 2008, we get an amendment, and it's called the National Defense Authorization Act. And it's National Defense Authorization Act, but it amends FMLA. And how does it do that? It creates 2 new categories of FMLA leave. It creates a qualifying exigency leave and a military caregiver leave. So not only now do you as employers have to monitor your employees for purposes of births, adoptions, health conditions of a loved one, their own serious health condition, but now you need to know whether they are caregivers or are in the military themselves, because they too may be entitled to FMLA leave. What is qualifying exigency leave? It's a new category of 12-week unpaid leave for immediate family members of reservists and members of the National Guard who are called to active duty. If somebody is called up to go to active duty, Afghanistan, Iraq, Biloxi, they may qualify for qualifying exigency leave. Okay, so if you have a spouse and their husband is in the National Guard and that husband gets called to active duty, your FMLA, National Defense Authorization Act flag antenna goes up because you may have to count this leave as FMLA leave. And what is qualifying exigency leave? It's leave where an employee can go and assist because of the circumstances surrounding the being called to active duty. It's where you have a spouse, a son, a daughter, a parent, somebody's being called to active duty, and you have to go and do something to assist them or make preparations because they're going away. The regulations have come out, and things like short notice deployment, military events, related activities that surround being called to active duty, child care and school activities. Well, what do I mean by this? Somebody's called to active duty, and now I got to find a different child care arrangement. Somebody's called to active duty, and I'm really bummed out because my spouse is going to Iraq for a year, and I need to go get some counseling. That qualifies. Somebody's called to active duty, and they need to make some financial arrangements. They need to go see a lawyer about a will or a power of attorney. That's qualifying exigencies. They get FMLA leave for that. So, and it makes sense, right? It makes perfect sense. And once again, where are we at in the hierarchy of fact patterns here? You don't want to deny this leave because these are bad facts. These are vulnerable facts. You're going to have somebody who's being called to active duty to go serve their country, and you're going to be the person saying you don't get the leave. You probably want to err on the side of giving the leave if it's close, because as you can see, the regulations from the Department of Labor, the Department of Labor handles the Family Medical Leave Act. Go to the DOL.gov website, www.dol.gov, and that's where you'll find all the FMLA forms. That's where you find all the information about the Family Medical Leave Act. Department of Labor. The ADAAA, well, that's handled by the EEOC. So you got to go to the Equal Employment Opportunity Commission to get that information. But as you can see, both of these agencies have promulgated regulations for these laws. But and things after somebody returns from qualifying exigencies, rest and recuperation, post-deployment activities, those might qualify. But if somebody gets called to active duty, somebody's spouse gets called to active duty, you immediately think FMLA. And before you deny that leave, you better make certain that you can, because it's going to be a difficult fact pattern. Any questions? Next type of leave, the military caregiver leave. And this is a new category of leave. It's different than the qualifying exigency. Okay, qualifying exigency, you get called to active duty. Got to make arrangements. Military caregiver leave. What happens there? Someone got hurt. Someone got hurt while they were in the military. And now you need up to 26 weeks. 26 weeks in any 12-month period to provide care for that individual. So if you learn, and it doesn't have to be battlefield related. It can be any type of injury through the service of their country. So if somebody's on a weekend, they get called out as a reservist. Well, we'll see in a moment, but this applies still. They get called out and they break their ankle while they're doing some type of drill. That'll work. The spouse may have to stay, if medically necessary, to care for the injured service member. And he or she would get 26 weeks of unpaid leave. And it's the same FMLA principles that apply. So what happens is you got to keep track of the 26 weeks. You got to maintain their benefits, keep their position, restore them to the same or equivalent position when they return. So there's military caregiver and there's qualifying exigency. Any questions? I have not seen anything about that, but that's a great question.
I mean, because next of kin,
Next of kin,
I'm registered.
if you're registered, you could be. You know, and this is one of those situations, if someone shows up and says, I'm next of kin, I'm going to say, all right, you're good to go. I'm not going to dispute it, you know, because it happens so infrequently. But I guess if that's the case, I haven't seen anything interpreting next of kin, but if they show up with that type of documentation, then I would give it to them. So what happens next? Well, the National Defense Authorization Act is then amended again, and it's amended in 2010. So we have the National Defense Authorization Act of 2008 that amends FMLA, and then we have the National Defense Authorization Act of 2010 that amends itself. And what does it do? It expands both of these leaves. Expands military caregiver and qualifying exigency leaves. Qualifying exigency leaves are now expanded to employees with family members in the National Guard. Okay? So you don't have to be called to active duty. You could be called to National Guard duty. Significantly different. Somebody now gets called to Biloxi for a weekend mission with their Ranger Battalion group, and the wife needs to leave on Friday to pick up the son from school because the husband's not there. What's that? That's FMLA leave. That's FMLA leave. And you wouldn't know that, right? I mean, nobody's, because it doesn't, nobody's being called to active duty, nobody's injured, but that's now where we're at. So it's an administrative layer on all of you now to know who's in the military and who's not, and who's gotten called to active duty and who's gotten called to National Guard. Military caregiver now has also been expanded, and now it includes people who have been honorably discharged from the military. So now you don't even have to be currently in the military. You could have served in the military, been discharged, have some type of impairment, and your spouse may be needed to care, or next of kin or whoever, it may be needed to care for you even after you've been discharged. That's FMLA. Yes. Great question. The question is should we put some type of form together, some type of document that would alert us to who's in the military, who's in the National Guard, so we'll know? You can do that, and that might be a way to get ahead of it. Because what will probably happen is you won't give the leave. You'll count somebody as absent. You'll deny them this, not knowing. And then we'll have the misunderstanding will lead to some type of litigation. You know, that's what lawyers do. We write down things, right? That's the old saying, doctors bury their mistakes, lawyers write them down. I think you should write that down. I think you should write down, maybe make a form, create a document, get ahead of the game so that you'll know who's in the military, who's not. But now, you know, now you got to even know who's been discharged. I mean, how do you know that? And not only do you have to know who's been discharged, but, well, I'll get to that in a second, but the military caregiver has been expanded. It also allows, let's see, now entitles an eligible employee who is the spouse, son, daughter, parent, or next of kin of a covered service member to take up to 26 work weeks of FMLA in a single 12-month period. And that's what I was getting at earlier. You know how we use the rolling periods in FMLA? I don't know if they're going to use the rolling period in this FMLA. I think they're going to just say you get 12 weeks. Or you get 26 weeks in a 12-month period. And what I mean by that is there may be situations where you can actually stack these leaves. I haven't seen them say that you can use a rolling period, so I don't know if they're going to allow that. Which means so you get 26 weeks, say June to December, and then you come in and say I need from January to June now. And so what does that mean? That might mean 52 weeks because it's 12 months if they do it calendar-wise. We'll have to see, but that's a potential. I think the idea is to expand the coverage as great as you can. And so because of that, I think they're going to allow the employee that freedom in that regard. Yes, ma'am.
Do you gain some January to December?
I think that when you go in to your office, you should try to define your 12-month period for purposes of military caregiver leave, so that it's abundantly clear, because I think it's like FMLA leave now. If you don't put down how you calculate it, the employee gets the best method, right? If you don't say I'm going to go rolling forward or rolling backwards, then they get whatever is beneficial to them. And I think that will apply here. Okay, so that's a great question. The question is, should I go back to my office and modify my military caregiver FMLA leave to be a rolling 12-month period? I would do that. Yes, 5 for both. You could have people out all year round. I think that's what someone just said. That's the case, yes. That's what we're looking at. But you know, I mean, and if you look at it though this way, this is a very this is a very worthwhile situation. I mean, these are individuals who have gone and served the country, and so Congress is trying to help them. However, you got to run a railroad, and you need workers to run that railroad. So I understand. And the extended time period for a covered service member is 5 years after they're discharged. So now you got to keep track of somebody who's discharged up to 5 years, because if they have an issue 5 years after their discharge, they have an aggravation of an existing injury. You're probably going to see this in mental impairments. People who are discharged, and 2 years or 3 years later they have some type of post-traumatic stress or something along those lines, that will qualify. That will qualify. And serious health condition has been expanded to include aggravation of injuries that existed before they went in the military. So if I had a mental issue and I went in the military and I'm fine, and I come out of the military and it's aggravated because I've now just been in combat, that's covered too. That's covered too. So administratively, you guys have a lot more issues under FMLA to be mindful of, and you may want to get your arms around these issues, because I think as we continue in these worldwide conflicts and wars, this is now law going forward. All right, let's switch gears. We have FMLA, we have the ADAAA. We're going to talk about how they interact in a little bit. Here's another law that's out there. Don't know if you guys are aware of this, but last year, 2010 actually, and I think the regs were promulgated last year, we have the Patient Protection and Affordable Care Act. And what does that do? I'm just going to mention this briefly. Now, this is under the Fair Labor Standards Act, right? The Fair Labor Standards Act, which governs pay. Governs pay, but we find some medical issues for that. And what it now requires, this Affordable Care Act requires a reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth, each time such employee has the need to express the milk. And they need a place to go, not a bathroom. You can't go, hey, hit the bathroom on the second floor. That doesn't work. You got to provide a place for them to do this. And that's a recent amendment to 2010 to the Fair Labor Standards Act. So the Department of Labor, they're also going to promulgate some regulations on this, but you can see now that now when you have an issue of pregnancy and somebody returns, you think, okay, fine, they've returned. FMLA leave is over. They're back at work. Not really. They still get leave if they want to do this at work. And you have to give it to them. I haven't read where they require a refrigerator. No, you may be able to say you got to bring your own cooler in, and actually I would go with that because I'm not going there, but I've overstepped the line. All right, so here's another amendment that's out there, the Uniform Services Employment and Reemployment Act. And I know this is an amendment. Well, it is an amendment, and we'll get to it in a minute. But you guys know about this law. This is when people are called to duty. They get their job back if they apply within a certain amount of time based on the length of time they were out. And they get it with the same seniority. This law's been around forever. But now we have this addition to it. This Veterans Opportunity to Work, called Vow to Hire Heroes Act. Vow to Hire Heroes Act. Veterans Opportunity to Work, signed by President Obama in November 2011. Basically what this does is it creates a new cause of action. You cannot create a hostile environment against somebody who served in the military or is serving in the military. That is a protected category now. Individuals in the military, even if they're National Guard, cannot be harassed because of that. Why do we need this law? Yes, sir. How many times can they re-enlist and us be on the hook for the Florida retirement system?
Yes, ma'am. Yes, sir.
Ooh, I don't know. I'm not a pension attorney. But I'd assume that they can re-enlist as many times as they want. I don't know of any prohibition. That's a great question. I've not seen that type of situation, but I think that the way that...
We went through it.
You did?
Yeah.
I don't know of any prohibition on the number of times somebody can keep re-enlisting for purposes of getting vested in the Florida retirement system. But I would assume that that type of situation, I guess, could happen. There could be, I guess, a abuse type of situation. Yeah. Yes, ma'am. Well, it's an unfortunate, I guess, byproduct of what this is. But you're seeing expanded coverage for military service personnel. And there can be situations where either the military is slow and it's hemming you up in terms of how you're paying benefits, or a service member, I guess, theoretically could, I guess, use the system to his or her advantage and try to get FRS vesting without really ever working because they're on leave. But now we have this Vow to Hire Employees, or Heroes Act. And this is where it came about. And you're going to want to go back and you're going to want to modify your policies because of this, because this is out there. This is a case from last year, 5th Circuit, which is Louisiana, so it's close by. Texas, Louisiana, Mississippi, 5th Circuit. Class action brought by pilots of Continental Airlines. The pilots brought it against Continental Airlines because their managers were making comments to them. They're all reservists, but they fly for Continental. Managers making comments to them. They start complaining about these comments. They're saying, this is a hostile work environment. What are the comments? Comments are, if you guys take more than 3 or 4 days a month in military leave, you're just taking advantage of the system. I used to be a guard guy, so I know the scams you guys are running. Continental is your big boss. The Guard is your little boss. These are the statements that were made against them. They sue. They claim, you're harassing us because of our military service. 5th Circuit says, well, that may be, but there's no law that prohibits it. So they dismissed the case last year. So what happens? Congress creates the Vow to Hire Heroes Act. And now you can't do this. You can't harass somebody who's in the military. What are you going to need to do? Well, the standard you're probably going to use is the same standard you use for Title VII harassment cases. So go back to your policy manual and include military service, where it says race, age, gender, national origin, religion, military service included. Military service is included. You're going to want to have a complaint procedure that includes military service claims. Somebody has harassment allegations. They're saying it's because of my military service. My supervisor's saying blah, blah, blah. They report it the same way they do any other type of claim of harassment or discrimination. So you modify those policies because the Vow to Hire Heroes Act has created this cause of action. And you know, we would be foolish to think that this doesn't happen. I mean, I think some people may look at National Guard and reservist type of situations and be critical of it, like these Continental people were. So you're going to want to modify those policies so that that doesn't occur at your workplace. All right, now this is about microscopic, and I knew when I made this slide that you might not be able to see it. So I apologize for that, but what I'm going to do now is sort of shift gears, and this is where the rubber meets the road. We've covered all the new amendments. We've got the ADAAA Amendments Act, we've got the Family Medical Leave Act with National Defense Authorization Act, and then the amendments to that act, and then we have the Affordable Care Act, and now we have the Vow to Hire Heroes Act. We're all acted out. You guys know it all now. Now we're going to talk about scenarios of how the ADA, FMLA, and workers' compensation come together, okay? Because this is what really happens. These are the calls I get all the time. And I want to talk and I want this to be as interactive as you guys want to be. But, you know, workers' compensation law basically allows for light duty for any workplace injury. What's your obligation under workers' compensation law? File a claim of injury. Even if you dispute it, file it. Let the carrier sort it out. If you have light duty, you got to give it. You're going to have to give it to them. And then that way, your carrier will be happy because you're going to be paying some of their wages, and the carrier's not on the hook for it. We've already talked about ADA and FMLA in terms of its application. The ADA only requires 15 employees. FMLA requires 50 or more, but you all are public entities, so it applies. And the ADA now has a lower threshold of disability. FMLA has a serious health condition, which is basically 3 days sick with a trip to the doctor or an overnight stay in the hospital. How do these things come together? Here's the question. You get a family member's medical problem. Somebody calls in and says, my wife, my husband, my son, my daughter, sick. What happens? Well, there's only two things that can happen. You only have application of two laws. If it's a family member who's sick, it's FMLA, because it's not an on-the-job injury, or it's the ADA. The ADA could apply if the family member has some type of condition that you can regard the employee as disabled. For example, if the family member has HIV, there may be a regarding of the employee as having HIV or something along those lines. So the ADA can come into play, but likely doesn't. But the Family Medical Leave Act applies. Okay? So if you have a situation with a family member's medical problem, you're only talking about FMLA, generally, the general rule. Unless there's a regarded as, the ADA won't come into play, and clearly the workers' compensation law doesn't either. Employees' pregnancy. You have an employee who becomes pregnant. What laws apply there? Well, obviously workers' comp doesn't apply because pregnancy was not the result of an on-the-job injury, and if it was, we got some real, we're going to do an investigation to get to the bottom of that. But FMLA kicks in, obviously. Everybody knows if it's pregnancy, it's FMLA leave. If it's pregnancy and it's normal pregnancy, what I mean by that is there's no complications, the ADA does not apply to the routine pregnancy. But if there is some type of bed rest, if there's some type of gestational diabetes, there's some complication, then the ADA is going to come into play, especially with the lowered disability and limitation requirements. So, employees' difficult pregnancy, FMLA, and the ADA. Now, there is a Pregnancy Discrimination Act, which is often misunderstood. Well, I remember I had a case. One of my first Pregnancy Discrimination Act cases. And it dealt with a tree trimmer company, a big tree cutting, the tree trimming cut down trucks that chop up the wood and make mulch and all that stuff. A woman was a crew leader. She ran a chipper truck, which is the truck that has the big chipper in the back that you throw the logs in and mulches them up. And she had 2 guys that worked for her, and another truck, or there was 2 other trucks, and together these 3 trucks formed a crew, and she was the foreman. She ran the chipper, and the other 2 guys ran bucket trucks. They would go up and saw the limbs down, and she'd throw them in the chipper. She became pregnant, and she's a pretty rough and tumble gal. I mean, she was, she liked this job, and she was good at it, and she was very well respected. And she would run this chipper truck. Well, as her pregnancy continued, she would complain to her crew members. And these are good guys, good country guys. They're trying to help her, but she wanted to keep working. But she would say, pushing the clutch in on the truck is hurting my stomach. Can you grab that log for me? I'm not feeling so well today. And they're like, hey, Mary, take it easy. You're pregnant. Mary's like, oh, this will pass. I'm good. I'm good to go. So Mary's working one day and picks up a log, and now I didn't know this, but evidently these chipper trucks have blades inside of them that turn, and based on the way they turn is the way it pulls the logs as soon as you put them in. So if they turn, let's say clockwise, and you throw it in, it's going to whip the log to the right. So you want to stand on this side when you do it. Well, she didn't do that. She takes a big long stick and throws it in, and it whips it around, it hits her in the stomach, knocks her down, knocks her out. It's out on the concrete. Like, whoa, guys are freaking out. Company calls. She shakes it off. She's fine, but very distressed. Company calls, says, Larkin, what do we do? I mean, she's going to get hurt. We're putting her on FMLA. You're going home. This isn't safe for you. She says, I'm not going home. You send me home, I'm going to sue you. Larkin, what do we do? Ooh, I don't know. Send her home. Put her on FMLA. The other side of this is she's going to get hurt. I'm worried about that. I don't like to admit to being wrong, but I was wrong. Pregnancy Discrimination Act doesn't allow you to treat somebody better because they're pregnant. You just got to treat them the same as somebody who's not pregnant. So what were we doing? We were discriminating against her for all the right reasons based on her pregnancy. Which is, the moral of the story is, Pregnancy Discrimination Act is actually the opposite of what one would think. It doesn't require beneficial treatment, it requires the same treatment. So whatever you give to a non-pregnant employee is what you give to a pregnant employee. So if somebody has a pregnancy, that's how they're to be treated. Not more favorable, just the same. Child with medical problems, scenario 3. And this is how I break these things down. When you guys call me, a lot of times someone calls and says, someone's hurting this and that, and they're on workers' comp. And, okay, what happened? Who are we talking about first? Who are we talking about? We're talking about an employee. Okay, only certain laws can apply. We're not an employee, only certain laws can apply. It's a child. Somebody's child's sick. What laws can apply? We've got 2. FMLA and the ADAAA. It's the only 2 that can apply. The ADAAA, if they're regarded, very unlikely, but it's the only 2 that can apply. So if you're talking about an employee's child with medical problems, the issue's FMLA. Job injury. Now we're in murky water because everything applies now, except for the Pregnancy Discrimination Act. Workers' comp, ADAAA, FMLA. If somebody is injured on the job, they get workers' compensation. If the injury is permanent or substantially limiting now, even if temporary, the ADAAA comes into play. So they get the protections of that law. And they also get the protections of FMLA. So what wins? We got all 3 of these things together, what wins? We'll talk about that in a minute. If the employee is unable to perform the essential functions of the job upon return from leave, what happens? Well, there's a couple of options. if somebody returns from FMLA leave and they can't do the essential functions of their job, then you're under no obligation under FMLA to reinstate them to the same job. But what happens is the ADA may come into play, and now you have a question about accommodation. FMLA only gives you 12 weeks and only requires reinstatement to the same position. But the ADA is longer than 12 weeks. Okay? So if somebody needs more leave, that's what you see. That's what typically happens. Somebody comes in and says, my FMLA leave's expired, but I need more time. I want to go on unpaid leave. Can you give someone unpaid leave as an accommodation? Yeah, absolutely. Are you required to give somebody unpaid leave as an accommodation? No. But if you have it and you've done it in the past, you better do it. Better not start now. But if you've ever given anybody unpaid leave, you got to give it to this person too. Now, what if they come in and they say, I don't know how much leave I need. I mean, I'll know, I got to get my medication right. I'm going to go see my doctor in a month. And so maybe in a month I'll be better able to tell you, but I might need 9 months of unpaid leave. I might need 6 months. I don't know. Do you have to give that leave? No. Under the ADA, you're only required to give leave, unpaid leave, in an extension of FMLA if it's definite in time. So if somebody comes in and they say, I don't know how much time I need, I just need more time, you're not required to give that as an accommodation. Why? Because you can't evaluate whether that's going to be an undue hardship, because you don't know how long it's going to be. You can't give somebody indefinite leave in the future, because how do you know when they're ever going to return? I can't keep this position open or have these other people keep filling it in perpetuity for an indefinite period of time. So it's only leave requests that are definite in time. Now, that begs the question, well, somebody comes in and says, I need more time, and you say, how much time do you need? And they say, I don't know. Do you go, aha, I'm not accommodating that because it's indefinite? Or do you say, well, why don't you just start out with a month and we'll talk about it after that? What would you do? What should you do? Probably do that. You know, why? Because this is a bad fact pattern, and you don't want to be the individual that seizes on some type of technicality, because, you know, judges aren't real good at applying this. And if it smells bad to them, they're gonna let it go to a jury, and a jury's gonna hit you. So if you get an indefinite request, maybe you want to say, okay, look, why don't we start with a month? Why don't we start with a week? Why don't we start with some definite period of time? Let me give you that time to see how things shake out. Bring me a doctor's note in a month. Yes? But as doctors will often do, they'll say they don't know, but you can. You can. The question is, can I make the employee go back to the doctor and give me a definite time? You can try that. And that is the case. And you know, because they'll never ever exhaust FMLA, because they're not taking enough of it to exhaust it, and so they're perpetually on this intermittent leave cycle, which essentially they're now disabled, and that's their accommodation, is whatever that position then becomes. Because if you're in intermittent leave, you can do what on intermittent leave as an employer? You can do two things. You can transfer an employee to another position. If somebody goes on intermittent leave, they say, I need 4 hours off every day. I need 2 hours every Monday, Wednesday, and Friday to sit and have my medication take effect because it makes me nauseous. If this is interrupting the work of that employee, you can transfer that employee under FMLA to another job. Perfectly allowed to do that. If that FMLA qualifies as an ADA, you better do that. You should do that, because you can't just fire them. Or if you leave them in the position, what can you do? You can reduce their pay while they're on intermittent leave for the hours that they don't work. You can convert them, if they're exempt, to hourly. Create an hourly rate for them and reduce their pay by the hours they're not working. Fair Labor Standards Act and FMLA come together, allow you to do that. Yes, sir. What if somebody's out on FMLA leave or out on workers' comp leave or they're disabled?
Are we violating their First Amendment on that?
No. That's the same situation where, you know, Joe says I'm out on FMLA leave and you know, Charlie rides by his house and sees Joe on the roof re-roofing his house, and you say, I thought your back hurt. I thought you were out on FMLA leave. If you get a Facebook page and you see, you know, Happy New Year 2012 and there's Joe partying it up in South Beach, and you look and Joe's out on FMLA leave, can you use that evidence to say, hey, wait a minute, this isn't legit? Absolutely. You could call Joe in and say, hey, what's this? First of all, where is this place? But you can definitely, because that would be facts and circumstances that would bring into question the veracity of FMLA. And if you have that, then you go send him to a second opinion. Or if he's abusing it and you learn of it, then you could fire him because he's untruthful. Excellent question. Did everybody hear that? The question is essentially, we have somebody who's on intermittent leave who's required to care for a loved one, a mother, a spouse, whatever the case is. But he or she is doing this, caring for this person in such a way where it's in the middle of the day or it's interrupting work. Can we require or ask this person, hey, is there any way you can do this like during lunch or before or after work? Can we do that? That's the question. Yes, you can. Say, hey, I know you got to go get this medication, or I know you need to take your mother to therapy, or I know that whatever the case may be, but is there a way you can do this from 12 to 1 because you're on lunch? Now, if they come back and say, no, there's no way because X, Y, and Z, okay, fine. Then you're going to have to give it to them. But they don't, just because they get this intermittent leave, get to schedule it whenever they want. If there's a way that they can pick up medications or care for the spouse or loved one that doesn't disrupt work, you can require that. And you should. Great question. All right, health insurance coverage interplay. FMLA requires you to maintain insurance under the same conditions as if they were working, okay? So if they pay premiums while they're out on FMLA. If they don't come back, you can recoup those premiums. Good luck, but theoretically. ADAAA, no require unless you're not required to keep them unless you keep them for individuals who are on similar leaves. Like if they go on pregnancy leave, do they get insurance coverage while they're out on pregnancy leave? If you do that, you got to do that for the ADAAA because you can't treat disabilities different than non-disabilities, right? Pregnancy Discrimination Act, we already discussed that. Part-time employment, this is the intermittent leave issue that you just brought up. Part-time employment can be an accommodation under the ADAAA, okay? But if you don't have a part-time job, you're under no requirement to create one, okay? But if you have one, you got to look to fill it. So, for example, my school bus assistant who's incontinent, if I say, look, we don't have any full-time jobs, but I got this part-time job. And I know it's only part-time, but it's work. Do I have to offer it to him? Yeah. Nod your head, yes, absolutely. Under FMLA, yes. Under the ADAAA, no. So the question then becomes is why are you transferring this person? Is it because of their own disability? Like my friend? Yes. Right. Now we get into this situation too where let's say I have an open position, and we're just about finished, and I know one thing, not to impede on break time in these, but let's say I have an open position, right? And my assistant bus driver wants that position. It's open and he qualifies for it, but I got 15 applications for that position, and there's some people that are a lot more qualified than him. What happens? Does he get it, or can I interview and give it to the most qualified? He gets it. He gets it. Why? Because it's an accommodation. An accommodation wins. We're accommodating him. He wins. Okay? So transfer to an alternative position. If it's open and he's qualified, he gets it. He doesn't have to compete for it. All right? Let's see, this is intermittent leave. We can deduct their pay under the Fair Labor Standards Act. Part-time employment we discussed. The interplay. The interplay of all of these laws, the point of everything here today is where the ADAAA or FMLA come together, the employee gets the benefit of whatever law is greater. Whatever law provides more protection, that's what they get. Okay? Light duty. If you have light duty, you got to give it as an accommodation under the ADAAA. If you don't have a light duty, do you have to create a light duty position? No, you don't have to. Which means you don't have to give a light duty job as an accommodation if you don't have one. So if you don't have them, don't go out and make them. But your workers' comp carrier is going to scream at you because they want you to put people on light duty. Now, if I give somebody light duty and they want FMLA, can I make them take light duty? No, I can't. If I say, hey, here's the light duty position, I'm going to offer that to you, we'd like you to take it, he or she says, no, I'm just going to take my 12 weeks. No, you're not. You're coming to work. It's light duty. They get FMLA. They get that right. Why? Because federal law trumps state law, and the federal law gives them more benefit. So they win. However, if they refuse a light duty position, that may undermine their ADAAA claim. Okay? So let's say I have light duty. Somebody's injured on the job. I offer them light duty. They say, no, I'd rather have FMLA. My workers' comp carrier is going to be upset, but I have to give them FMLA. Okay? But they're going to get paid by workers' comp while they're out on FMLA, but they get 12 weeks. Now, if I say, well, here's the light duty position, they say, no, I want FMLA, then they're not qualified under the ADAAA because they're not accepting that as an accommodation. Now, what will happen then is once FMLA runs out, and I tell them you're out of FMLA, guy, you know, you got to, here's your light duty position, they'll probably take it then under the ADAAA as an accommodation and come back to work. That's generally speaking what happens. But that's where we're at. Can you run FMLA concurrently with an employee's workers' compensation leave? Yes, and you better, or you're going to stack them. So if somebody goes out on FMLA or on workers' comp, start running their FMLA concurrently. Return to work issues. FMLA, you reinstate to the equivalent position. We've already sort of discussed this. Employment offer satisfies your obligation. There are some exceptions to reinstatement. Key employees, those are very high-level compensated employees. You don't have to reinstate them, but you have to give them FMLA. Or if you learn that somebody unequivocally says, there's no way I'm coming back to work. I mean, I'm done with this place. They still get FMLA. They get their 12 weeks, but you don't have to reinstate them in that regard. But you may want to get that unequivocal statement in writing before you do that. Another exception to FMLA reinstatement is where somebody's terminated or laid off while they're out on FMLA. Always dangerous, but I've had situations where we've discovered wrongdoing when somebody's out on FMLA. Aha, look at all these, you know, poor performance issues that we've found. I'm always hesitant in that because somebody's out on FMLA and now we discover that they weren't ever doing their job right, and so we fire them while they're out. Always tough because they're going to say you're targeting me, you're retaliating against me, but you can terminate somebody for poor performance while they're out, and you can also lay them off while they're out. You can say, we're cutting down, we're eliminating this entire department, and I'm sorry you're on FMLA, but you go too. But those are the exceptions. ADAAA, you got to return them unless there's an undue hardship. You guys are public employers. It is a very hard situation, very difficult situation to prove undue hardship. Most of the time it comes down to finances, and let me tell you, the public, I know you guys are struggling with budgets and cutbacks and everything else, but Joe Citizen's not going to buy it. So if you're claiming that it's an undue hardship to keep one employee employed in this position as an office assistant, 3-year court specialist 1, they're not going to buy it. I'm just telling you straight out, unless it's just some serious financial situation. So reinstatement is, generally speaking, under the ADAAA, always an option. Repayment of benefits. Workers' comp, you get no recovery. FMLA, you can try to get the payment back, but we've talked about that. Good luck. That is all, everyone. I appreciate it. Sorry to keep you over the time. If y'all have any questions, seriously, email me. I'll stick around for a little bit if you want to talk, but it was my pleasure. Thanks.